Good afternoon, everyone. We're going to go ahead and get started. Thank you for taking time out of your busy day to join us. I'm Jenna Kirsten, your moderator for today's webinar. I'd like to welcome everyone to today's session on GDPR, where we'll be discussing some hot topics like consent, privacy policies, and recent enforcement activity. Let's go over a couple of things before we dive into our discussion. All attendees will be muted throughout the session, but we do encourage you to ask questions using the Q&A feature. We'll reserve some time at the end to ask those and monitor those throughout the hour. This session is also being recorded, and all attendees will receive a link to the recording as well as a copy of the slides in your inbox tomorrow. Now, just a little bit of background about who we are before we get started. Kirkpatrick Price is a licensed CPA firm providing assurance services to clients worldwide. Our firm has over 13 years of experience in information assurance by performing assessments, audits, and tests that strengthen information security and compliance controls. We offer both regulatory compliance and information security services. We provide consulting services such as policy and procedure drafting, risk assessment, internal audit plan and development, and readiness audits. We also provide guidance and audit services on frameworks such as SOC 1 and SOC 2, SOC for cybersecurity, PCI DSS, HIPAA, HITRUST, FISMA, ISO, and GDPR. We also encourage you to connect with us by subscribing to our blog, visiting our library of recorded webinars. You can catch up on this series at any time, and following us on LinkedIn, Twitter, and Facebook. Now I'd like to welcome today's speaker, Mark Heinle. You may have heard him before on our previous GDPR webinars or HIPAA webinars and videos, and we're lucky to have him today. Mark is a regulatory compliance specialist here at Kirkpatrick Price and has over 10 years of experience in private practice, regulatory affairs, and internal regulatory compliance. He's kind of our go-to GDPR guy, and I'll hand it over to you, Mark. Let me make sure we can hear you. Okay,
thanks, Jenna.
You are good now. Yep.
I'd like to add my welcome to all of you for joining us for today's presentation on GDPR 1 month in. We're going to talk about some developments now that we are essentially 1 month into the enforcement of GDPR. And while the law has been in existence for a couple of years, in general, the compliance activities and industry awareness has really peaked since May 25th. So the goal for today's presentation is to cover some developments. Certainly can't cover all of them, but we'll cover a few. Before we start, I need to provide my own legal disclaimer to establish that this presentation is provided by Kirkpatrick Price for educational and/or informational purposes only and does not constitute legal advice. Therefore, no attorney-client relationship is established by viewing this presentation. Should you need legal advice, please consult with your own attorney. Now that we've got that out of the way, we can talk about our topic for today. As I mentioned, it's GDPR 1 month in. This presentation is designed to address several different areas that are connected because either they have broad impact or interest, they provide clarity to topics that are particularly confusing or particularly sensitive, or they are just examples of first instances, for example, the litigation that we're going to talk about at the end of our presentation today. So that's the common thread, is what's happened within the last month. Particularly, we're going to talk about consent and really use that as a place to talk about legal basis for processing in general, but focused on consent and privacy policies. And then we'll spend some time talking about different regulatory developments, both organizationally and actual proposed and existing guidelines. And then we'll wrap up with some litigation related to GDPR before we do a summary at the end. So that's our agenda for today. And as Jenna said, we should have some time for questions at the end. So first, let's talk about consent, and specifically the concept of pay for privacy. This topic came about as a result of several organizations using what's sometimes called a tracking wall to provide different scenarios and different ways in which to obtain personal data or provide an opportunity to opt out for users. Particularly, there was a case with the Washington Post, which is a newspaper based in the Washington, D.C. area in the United States, and they, on May 25th, established 3 different options for users perusing their news website. The first was a free option that was consent-based, which anyone could go to the website and view some of the news in a limited capacity as long as they provided consent. And in return for doing so, they would be consenting to being tracked by cookies and all of the marketing implications that would come along with that consent-based option. Then the Post also provided a $60 subscription-based option, which was simply provided more access to the news. It was unlimited, as opposed to the free version, which limited to either the number of hits or the content that was available. But the thing that was most of note and potentially considered even controversial was a $90 no tracking option, which provided you no different content or availability than the $60 version, but the additional $30 US provides you with the ability to not be tracked by cookies. And this is what's called a tracking wall, where organizations use a mechanism in order to create an incentive for an individual to either provide consent or to provide monetary options to not be tracked. And there are very different opinions about the compliance posture of tracking walls. And the reason there are different opinions about the compliance posture of tracking walls is because consent under GDPR must be freely given. And so there's a question about whether or not a financial incentive to consent to an option that does not allow for tracking of web use improperly influences consent, but that eliminates or reduces the ability for the data user the data subject to give that consent freely. And GDPR also addresses situations in the recitals where requiring consent, which is not necessary for the performance of a contract, should be avoided. So an example, in this case where you have someone potentially signing up with the Washington Post to have access to their news content, the question is web tracking necessary for providing a news website and a subscription to its audience? If web tracking isn't necessary for providing a news website, then it may be that tracking wall is improper. And it may be that if that web tracking is not necessary, that there is a lack of genuine choice, which is one of the elements identified with regard to consent, freely given consent in Recital 42. And then there's also the consideration of whether there's a disproportionate balance of power, which is an element of freely given consent discussed in Recital 43. Now, in the case of a news website providing a pay for no tracking, pay for privacy option in connection with or in addition to choices that are both free and paid, you could suggest that there is a genuine choice. And there's also, not only within Washington Post's website does the data subject have choice with respect to their consent, but there are other news sources where a data subject might get their content. And because news is something that is generally available across a variety of medium and a variety of competitors within the same medium, it's harder to identify whether or not there would be a disproportionate balance of power. You could consider an example where a take it or leave it approach might be more challenging if the data subject was an employee, for example, and an employer was forcing an employee to give consent or have some kind of implication with respect to pay or employment, or the controller was a healthcare provider and consent was influenced based on the provision of services, the release of test results or release of records, something like that, then there might be a more likely argument for a disproportionate balance of power where the data subject says that, I have to say yes to this or I lose my job or my pay is impacted, or I have to say yes to this or my health care is impacted. And so, so this is one of the developments that came out as a result of May 25th, companies trying to navigate consent and the ability to be transparent and obtain the necessary consent from data subjects who are providing their personal data, while also navigating the reality that data subjects may not give their consent when they know that their personal data is going to be used for certain purposes. So one of the ways that the Washington Post came up with this was, and others have come up with this, is to create a tracking wall, is to create an exchange in essence of, if you're not going to give us your data, then you're going to have to trade off financial compensation to us, or you're going to have to give us your data. So that's kind of what the issue boils down to is consent really freely given if the data subject has to choose between giving their personal data or paying more or some other consequence that the data subject would not be inclined to pursue. So how do you comply if the take it or leave it approach is what's presented or is what's not compliant? What is a compliant solution for the scenario where you may have multiple activities going on, maybe multiple processing activities going on at the same time? And the answer is provided explicitly within GDPR, and that's separate consent for different processing activities, separate consent for different processing operations. So, for example, in recital 43, there's discussion of separate consent. So, for example, the Washington Post, if this tracking wall was considered non-compliant, the Washington Post could consider an option where it gives multiple consent for marketing activities or other certain activities that are not required for providing the news website. The Article 29 Working Party Guidelines specifically recommend that cookies not be an all or nothing proposition. So to take the Washington Post's situation and extend it even further, it's not within GDPR, it's not a prohibition against creating an all or nothing consent option for the use of cookies, but the guidelines recommend against it, that users, data subjects, be given the option regarding different cookie options, different tracking options, and the ability to select or reject those options individually, which gives the appearance, at least, of genuine choice and a more equal, proportionate balance of power. So one of the things that's come out as we deal with consent is what are the ways in which, beyond just the don't have boxes automatically checked and other sort of more generally known and discussed methods of dealing with consent, what are some other ways that consent has been considered? And one of those is to attach payment to it. A second issue is regarding consent, and this doesn't directly relate to pay, is what happened on May 25th and probably at the 2 or 3 days before that, when most of you probably got a flood of emails in your inbox that said, we've updated our privacy policy. And that flood of emails may be an indication that there is a misunderstanding of consent under GDPR. First, notice of an processing activity does not equal consent, because in addition to consent being freely given, consent must be unambiguous by clear affirmative action. So sending an email to an individual and having them not reply back to that email that says, wait, I object to this update to your privacy policy, does not mean that the data subject has consented to the update to a privacy policy. So if that's the purpose for sending that flood of emails out, then they haven't obtained consent. The second thing that potentially reveals, that flood of emails potentially reveals, is the thought process that consent is always required. And the truth reality is that consent isn't always required. And I would say, based on my discussion with clients and others in the industry and my review of content, that the issue around consent is probably the most misunderstood and confusing topic. It's often viewed as something that's required in all situations and in every case, even by organizations that would be considered processors. And the reality is that consent isn't always required. Consent is just one of 6 legal bases for processing. So if you have any of those legal bases for processing in general, then you are compliant with GDPR. More specifically, marketing is a legitimate interest. So if those individuals were sending out their privacy, those companies, those organizations were sending out their privacy policies, the updated privacy policy notice to an existing or potential client for whom they already had their personal data, they already had a legal basis in a legitimate interest. That's a legitimate interest. Marketing is specifically referenced as a legitimate interest within GDPR. Now, there is a balancing test and a need for legitimate interest. So just because you have a legitimate interest doesn't mean that you can process under that reason. Specifically, you need to have a need that's required, that processing is necessary to achieve legitimate interest. So if there was another way to accomplish that legitimate interest other than sending out marketing emails, then the first part of the legitimate interest test isn't met. The second part of it is a balancing test. So even if you did have a legitimate interest and that processing activity was necessary to achieve that legitimate interest, there wasn't another way to market to clients other than sending them the email, then you have to balance the data subject's expectations and consequences for that activity versus the legitimate interest. So from a marketing perspective, which is where most of the time legitimate interest is considered, you know, the expectation of a data subject is likely that they'll receive marketing material from an organization that's providing them with goods or services. And the consequences to that data subject are potentially more emails in their inbox, but limited consequences aside from that. So in that case, the balancing test is fairly easy to meet. But if you were dealing with special categories of data and certain processing activities related to that, especially if you were talking about profiling, then the legitimate interest test might be more difficult to meet. So if consent isn't always required and just sending out a privacy policy update to individuals doesn't necessarily equal consent, then where does consent fit in? As I mentioned, there are 6 legal bases for processing under GDPR, and consent is just one of those legal bases. The other 5 are a contractual basis, a legal obligation such as a statute or a rule, something non-contractual. The vital interests of an individual is a third reason. A fourth is a public task, for example, an official function of a government organization. And the 5th legal basis is a legitimate interest that we just mentioned a moment ago. So consent is just one of those 6 options that can be used for processing data in a compliant fashion under GDPR. Now, there are some implications and considerations when you're talking about consent that are similar to and different from the other 5 legal bases for processing. So, for example, explicit consent can be a valid basis for processing special categories of data. Special categories of data include healthcare data, trade union membership, data around race and ethnicity, philosophical and religious affiliation. Those kind of pieces of information are considered special categories of data. And not all legal basis for processing would allow you to process those special categories of data. But explicit consent is one that would allow you both to process generally, personal data generally, and special categories specifically. Consent is also a legal basis for automated decision-making, including profiling. So there is some value in getting consent in that it accomplishes, you know, if you were involved in processing special categories and in profiling, explicit consent would potentially resolve your compliance needs from a legal basis on both of those. And then finally, consent is a basis for certain international transfers. Apart from things like binding corporate rules or model clauses or adequacy decisions, consent can serve as a valid transfer mechanism in those cases. So it's not that consent is required all the time. Again, it's just one of 6 legal bases, and it has some implications in terms of special categories, automated decision-making, and international transfers. Now, one area where consent is different than the other legal basis, for example, a contractual basis or a legitimate interest, which are 2 other common ways that private organizations are likely to use as a valid basis for processing, is that consent can be withdrawn. A contract can't be withdrawn in the same capacity, and a legitimate interest, while the balancing test will still exist, it isn't explicitly withdrawn. So that gives you hopefully some clarity around the concept of consent, especially now that we're 1 month in. As I said, consent is probably the most confusing and misunderstood legal basis for processing. And it's important to note that consent must be freely given. So that's going to impact the way that organizations review whether they should be using consent as their legal basis for processing. And secondly, if they are using consent, the way in which they obtain consent. Are they combining consent, for example, with a contract? And if they are, is the data subject clear on the difference between the contractual elements and the consent elements? And is there an undue influence that might reduce the chance that consent is considered freely given? So also, there are times when consent shouldn't be connected with contracts, and that's not necessarily just a regulatory consideration, that's a practical operational consideration. There are times when a contractual basis for processing is going to be more advisable and more beneficial to an organization because, as I mentioned, consent can be withdrawn, and there are data subject rights implications for processing that are different for consent-driven processing than contractual-driven processing. Additionally, consent must be affirmatively given. The method of sending out an email notice and not hearing an objection back is not any more valid than the automatically checked boxes or the method that say if you continue to use this website or this service, then you are giving consent to our processing activities. Consent is not always required. Again, there may be superior legal basis for processing, including for special categories of data than consent, such as legitimate interest, contract, vital interest of a person, public interest or scientific interest. So there's other grounds that might be used, and organizations can cause themselves perhaps more challenges from a regulatory and compliance perspective if they're combining legal basis or if they're using legal bases that make their processing activities more difficult. And then finally, consent is different from other legal bases for processing because it can be withdrawn first, and it can provide a legal basis for additional processing activities, such as automated processing and special categories. Now that we've talked about consent 1 month in, we're going to move to our second topic, which is regulatory developments 1 month in. So the first of those is the creation of the European Data Protection Board, commonly known as the EDPB. This is the body that has replaced the Article 29 Working Party. It has, the EDPB has similar membership as the Article 29 Working Party. And in fact, at its first meeting on May 25th, the European Data Protection Board adopted guidance from Article 29 Working Party, such as the guidance on data protection officers and transparency and consent and portability. So just because the Article 29 Working Party doesn't exist anymore doesn't mean that its guidance is no longer valid. The potential difference between the EDPB and Working Party 29, Article 29 Working Party. A couple things. One is the purposes of the two groups is slightly different. European Data Protection Board has, I think, more comprehensive purpose. And second, it's more likely that the EDPB is going to obtain feedback from the public about its activities than the Article 29 Working Party was seen as doing. So this is the source for overall European guidance on GDPR. And as an example of their activity, one of the things that they have done is they have adopted some certification guidelines. These are proposed guidelines for the accreditation of certifying bodies. So these are not the certification standard for themselves, to specifically certify a controller or processor or a specific data processing activity. But note a couple of things about these guidelines that do give us some idea about what certification might look like. First, certification apparently won't apply to data protection officers. The proposed guidelines specifically reference that the certification would apply to controllers and to processors. And then secondly, of note is that certification will apparently apply to certain processing operations, potentially rather than an entire organization's data processing activities. For example, the guidelines give an example of a bank obtaining certification for its online banking operations, rather than all of its even online banking activities or web activities, because of the ability to distinguish those activities and evaluate and then certify those activities. So for organizations looking for an enterprise-wide certification, they may not be getting what they want. But it should be noted, as I said, that these certification guidelines are unfinished. The EDPB is accepting comments through July 12th, 2018. So if you are interested in providing your feedback, you still have an opportunity to do that. The format within the proposed guidelines is that the certification body would look at, in terms of providing its certification, the things it would look at are three things. First, the personal data that's being processed, the technical systems that are performing the processing, which would be hardware, software, and infrastructure. And then third, it would be the operational processes and procedures. And then additional consideration will be given to organizational and legal structure, the department, environment, and people within an operation, technical descriptions, and IT infrastructure supporting processing operations. Some of the questions related to the certification include, what's the duration of processing or duration of certification? Will it be, lifetime, or will it be for a limited period of time? And addressing industry standards, specifically some of the ISO standards for certification. So this is something that we commonly get asked about is, is there a seal of approval? Is there some sort of certification that you can provide? And the answer is that at this point, nobody can provide that certification. But one of the developments that's come out is that we're sort of one step closer with these guidelines for certifying bodies. So make sure to maintain an eye on those developments. An additional set of regulatory developments that's come out that is more member state specific regards data protection impact assessment scenarios. DPIA is the common abbreviation. So a data protection impact assessment is a process for identifying and minimizing risk to data subjects based on proposed processing activities that are likely to result in a high risk to data subjects, particularly those processing activities that either involve new technology or new systems, automated processing, including profiling, and large-scale processing of special categories of data. So GDPR is fairly general. It is general when it comes to a description of the kind of activities that require a data protection impact assessment. The law does spell out the required elements for a data protection impact assessment, but it also allows, GDPR also allows member states to create additional clarification around certain areas of the law such as data subject rights, and then also data protection impact assessments. So some member states have either proposed or implemented what are called white lists or black lists for data protection impact assessments. A white list is a list of processing activities that does not require, by its designation, a data protection impact assessment. And a blacklist is the opposite. It is a list of activities that are required by that member state to have a data protection impact assessment. So we're going to talk about a couple here just to give you some guidelines, and in case you're processing in those member states, then to give you some specific awareness of activities. And some of these have come out slightly before the May 25th date, but now that GDPR is enforceable, people have been able to move past sort of that initial phase of compliance and have moved more towards some specific activities like DPIAs. So in Austria, there is a white list. So these are activities that do not require a DPIA. For example, customer and supplier management, the logistics that go along with that, are considered activities that are not high risk and therefore do not require a DPIA. CMR marketing activities, which impacts almost every organization, have been determined by Austria to not require DPIAs. I think that's going to allow a lot of organizations to breathe at least a slight sigh of relief. Physical security controls, excluding biometrics, generally do not require a DPIA. So if you're using fingerprint or finger structure analysis or voice or eyes, those would still potentially require a DPIA. But your more basic physical security controls that involve, badges, magnetic badge readers, and those kinds of things do not require in Austria a DPIA. Access management, limited CCTV monitoring, and event planning are the other items on the list that do not require DPIAs in Austria. So I don't think anything in there is too surprising, but you will notice as we move on to a couple of other ones that there are both some areas of general consensus among the member states about what activities or types of activities should require a DPIA, and then a few areas where there is a conflict between the two. So, for example, Germany's blacklist includes large-scale geolocation processing. So, the examples that have been in the Article 29 Working Party guidelines, for example, related to a fast food restaurant using geolocation for customers at its restaurants would require DPIA. Multi-source data analytics. That's where an organization is combining data subject data from different sources and running analytics on those. So maybe a retail source, and then a web source, and then a physical location source, and then the use of some online service, and combining all those sources to perform some sort of analytics. Some employee tracking is going to require data protection impact assessment. Activities involving artificial intelligence, fitness wearables, rewards programs, and audio-video analysis. Now, it should be noted that, as far as I understand, this blacklist in Germany is proposed, so this list is subject to change. But you'll see a similar thought process with respect to, for example, divergence potentially between Austria and Germany in the employee tracking, whether or not physical security controls would be covered under that employee tracking. You might have two different takes between what's required and what's not required. But in the end, an approach to resolving these conflicts is that if one member state requires it and requires a DPIA, and you perform that impact assessment, then there isn't any conflict with other member states. It's simply other member states saying we don't require you to do one, but there's no negative impact from performing such an analysis. And then I don't have it on the slides, but Belgium has also proposed both white lists and black lists. Those proposals came out earlier this year. Just some examples on the blacklist to give you a sense of how it compares to the other two member states. On the blacklist, so that would be items that would processing activities that would require a DPIA. You have biometric data, used to identify people in both public and private spaces. So that's one processing activity that would require a DPIA. Large-scale processing of vulnerable populations, particularly processing the data of children, would require a data protection impact assessment. And then large-scale processing of behavior. So, for example, viewing habits, listening habits, browsing habits, clicking activity, physical behavior, and purchasing habits. If there was large-scale processing of those types of behavior under Belgium's proposal, that would require a data protection impact assessment. And then the whitelist, these again would be activities that do not require DPIA. Would be certain employment functions such as compensation and administration of employees. A controller's accounting practices would not require a DPIA. Processes carried out by foundations, associations, and nonprofits where those organizations have obtained the personal data themselves would not require DPIA, but that doesn't apply to processes carried out by those organizations where they've obtained that whitelist. Inclusion doesn't apply to when those organizations have obtained personal data from a third party. And then a fourth example from the whitelist would be processing activities by schools for management of its students. So the reason that these guidelines are important, in Austria, the whitelist is telling you what doesn't require a DPIA, so that's in effect. The others are proposals, but they give you specific examples where organizations can look at their own processing activities based on the blacklist in particular, and determine whether or not they might need to perform a DPIA, whether or not they're engaged in sort of audio-video analysis or analytics, whether profiling based on behavior, or I think processing special categories of data is almost always going to get you into consideration for DPIA. And then on the other hand, logistical sort of operational activities that involve processing personal data don't seem to require DPIAs. So it's helpful to get these lists so that you can get a better sense of whether or not a DPIA is required for you. Now that we've talked about data protection impact assessments, we're going to talk about data subject complaints and breaches. I spent quite a bit of time looking for numbers to get a sense of what's happening in the last month regarding, how are data subjects responding to the law? Are they aware of it, and is it impacting their behavior? Are they exercising, in particular, are they exercising their rights? If so, what rights are they most exercising, with what kinds of organizations and what member states? But that data, as far as I can see, isn't readily available. So I'm limited to some data from the Irish Supervisory Authority, which is called the Data Protection Commission, which kindly shared some data regarding just the first week of GDPR enforcement. So this was the week after May 25th, and the DPC received 1,350 combined complaints and inquiries. So complaints would be data subject complaints about the behavior of an organization, and inquiries would include communication from GDPR subjects, controllers, and processors to ask questions about compliance. So the DPC didn't distinguish between the two, so I don't know how many of each they received, but they also noted that they received 60 reported breaches just within that 1 week period. And so I don't have historic data to compare, for example, the week before GDPR became enforceable, to tell you how much of an increase it is, except to say that the DPC noted that it was a significant increase in both complaints and breaches compared to pre-GDPR activity. So what that tells us is that data subjects are both aware and acting on their right to complain to supervisory authorities. So that behavior is changing. And then controllers are self-reporting on breaches at a higher level than under GDPR enforcement than they were prior to GDPR enforcement. So it's interesting to see that both data subjects and organizations are acting differently based on the enforcement threat of GDPR. Hopefully more supervisory authorities will provide the kind of data that the Irish DPC put out so that we can get a sense of where threats and risks are, as well as some principles and potentially processes to learn from. So now we're going to talk a little bit about enforcement, and at this point, enforcement is for pre-GDPR violations. So none of the examples I'm going to provide to you involve activity that was on or after May 25th. Some of the activity involved actions that occurred even in 2017, so GDPR was in existence even if it wasn't enforceable. But there are lessons that we can learn from these activities about the fines and the nature of those fines, and also the issues that these organizations faced and some of the things that they should have done differently and that we can learn from. So, because of the length of time that an investigation takes and then the decision about enforcement activities, we're still, for example, for those 60 breaches that were reported to the Irish DPC, we're still probably months at least away from any GDPR enforcement, even if the incident occurred on May 25th, because of the length of time to investigate, make a decision on those activities. So there'll still be some time before we actually find out what is non-compliant under GDPR. Until such time, though, we have other activities and enforcement actions from supervisory authorities that we can learn from. And in our case, for today's webinar, we're going to talk about 3 from the UK and then 1 from France. So one of the reasons I think we can learn from these lessons explicitly is that the ICO, that's the supervisory authority for the UK, has put notes to editors when you go to its website and see the enforcement actions that it's taken. In some of these cases, it's put notes to editors referring to GDPR and its processing principles. And so, I think there's a specific inference there, explicit inference there, that we can learn from these enforcement actions, even if the incident occurred before May 25th, 2018. So for the first example, the Gloucestershire police were fined £80,000 for an incident from 2016 where the police force was investigating some abuse claims, and the abuse claims involved a multitude of victims. And in December of 2016, one of the members of that police force sent out an update to over 50 recipients by email and entered all of their email addresses in the to field and didn't blind CC anybody. So everyone was able to see other people who were potential abuse victims in that case. And then on top of that, to make it worse, the recipients of the emails included victims, witnesses, lawyers, and journalists, and they could see the names and email addresses of all the other individuals who were included on that email. And the email made references to some other parts of the investigation, some other organizations that were involved in the investigation. So there's a huge exposure based on the sensitivity of the kind of data that's being shared. And so the ICO didn't note the specific infractions, but I think it's fairly obvious from my perspective. One, sending that sensitive data via email was a problem in the first place. Second, CCing all the addresses of the potential victims was a second and the primary problem in this case. So I think what should have happened in this case is there should have been training on communication methods, and there should have been technical controls in place to limit the kind of data that's distributed via email. The second case is the British and Foreign Bible Society. This is a religious organization in the UK that is funded by donations, and they were fined £100,000 for a breach that put donors' information, including payment information, on an insufficiently secured internal network. And then the society put a service account on that network that the only access restriction on that account was what the ICO called an easy-to-guess password, and it was remotely accessible. So you had a large number of donors whose financial information was breached. And in this case, the issue was the security of processing, which is under Article 32 and is one of the principles of processing under GDPR. Acknowledging that this enforcement activity occurred before GDPR, but applies the same considerations apply. There should have been greater access restrictions to the donor information, including remote access and password policy, and then the security around that internal network should have been increased. So there were 3 or 4 different ways in which this organization could have secured the personal data here and avoided the breach and then the £100,000 fine. The third example from the UK is Yahoo, and this is a well-known incident, and it actually occurred in 2014, but the ICO just in this month in June just released and issued the fine amount for £250,000 against Yahoo. Just to refresh everyone's memory, the incident involved a breach of 500 million users because unencrypted security questions and answers were accessed and used by hackers to reset passwords and then gain access to those accounts. In this case, the ICO listed 4 specific things that should have happened, 4 specific lessons for us. First was the lack of organizational and technical controls regarding data extraction by unauthorized users. There should have been both organizational and technical controls to restrict the ability to extract data. The second was the failure to ensure that Yahoo's data processor, which was actually Yahoo Inc., located in the United States, had complied with appropriate security measures. So you had an oversight failure on the part of the parent company, Yahoo, for its processor. The third lesson was a failure to monitor the credentials and employees that had access to customer data. So apparently Yahoo was not monitoring those credentials enough to identify when there was a security issue. And then fourth was the length of time that the issue existed was undiscovered and unaddressed. So there were lack of controls, both organizational and technical, to identify and alert Yahoo regarding this breach of unencrypted security questions and answers. The final pre-GDPR enforcement activity we're going to talk about today involves a French company called Optical Center. They provide vision services and eyeglasses and some other hearing devices. And they were fined 250,000 euros, which was, at the time at least, was the largest fine in French history for an incident that was discovered in July of 2017. So at this point, GDPR is in existence, but just not yet enforceable. The issue was that the company's corporate website allowed customers to go to the website and access their invoices, which contain personal information in those invoices, but the company didn't establish any customer verification methods that would require those customers to authenticate their identity before accessing the invoice information. So you could just go in and put a couple of URLs in, and you could have complete access to the invoices and all of the information in those invoices. So the lessons from this incident are, it violated both the security of processing principles and the fact that there were not organizational and technical controls. First, the organizational control should have prevented the arrangement of invoices that didn't require authentication during the development phase. When that process was being designed, it should have been designed with privacy in mind. And then second, there should have been technical controls in place to require authentication. In this case, we have some insight into the level of the fines. The French said that the CNIL said that the fine was so great because of the sensitivity of the information included in invoices, which included both healthcare information and in some cases it included social security numbers. So that was one of the factors in the fine being so large. And then the second factor was the volume of records. There were 330,000 records involved in the access. So the lessons that we can learn are not only to create, customer verification, authentication methods, to have organizational controls that always bring privacy to the forefront. We're talking about how to process customer and personal data, and then also a sense of if we have special categories of data, the fines are likely going to be increased, and that's not a surprise to anyone, I'm sure. So our final topic today, to make sure we have some time for questions, is a brief update on some litigation that some of you may have seen. It was filed on May 25th by a data privacy advocacy group. It's really 4 different actions in 4 different member states, but it's filed against Facebook and Google. It was filed by Max Schrems and the organization he's a part of. He's the Austrian lawyer who previously and successfully sued Facebook over data transfers from the EU to the US under the safe harbor provisions that used to exist before Privacy Shield. The suit against Facebook is against Facebook itself and its subsidiaries WhatsApp and Instagram. And then Google, the suit relates to its Android operating service. So we kind of come full circle because the suits focus on consent, this kind of take it or leave it approach that we talked about at the beginning. And they're seeking, the organization is cleverly titled NYOB, I think, none of your business. And I think they're seeking approximately $8.8 billion, almost evenly split between Facebook and Google. The issue is NYOB alleges that Google's Android service creates a forced consent where you have to provide your personal data to Google in order to use an Android device. To me, that's a pretty clear example of an area where there's just disproportionate power between the two, the data subject and the controller, and also a lack of genuine choice in the matter. With respect to Facebook, the allegation is kind of twofold, at least. That one is that Facebook is capturing and processing personal data, including special categories of data, in order to profile data subjects without specific, clear, affirmative consent. That's Facebook is using information that they do know about you in order to connect with information that you haven't specifically provided about you, but they can identify because they have enough information about you. So they take your name, some of your other communication, some of your other personal information, and they can identify things like your sexual preference. That's a special category of data. Additionally, the argument about Facebook is that it's blocking user accounts in some cases when data subjects do not consent to the use or processing of their personal data. So, Facebook was the likely target for activity as soon as GDPR became enforceable, so it's not a surprise, and Google in the same boat. But what does that mean for the rest of us who aren't enemies of Max Schrems? One is that data subjects rightfully view consent differently than they view other legal bases for processing, which, they view consent and contracts different because data subjects are just less aware of when they have and haven't given consent than they are about the awareness they have regarding the execution of a contract. Even the least sophisticated data subject has more awareness about the execution of a contract. So just know, we're kind of back to where we started, that consent is a sensitive area for data subjects. And then in the court of public opinion, consent is viewed differently, more sensitively. And then I think it's also so likely to be viewed in actual courts and by regulators that consent is going to be viewed more sensitively as a legal basis for processing than other legal bases for processing, such as legitimate interest in contracts. So again, highlights the need to be aware of consent. So let's do our wrap up, and I think we might have time for a few questions. Know consent and know your need for consent. As I mentioned, consent is a complicated topic, so controllers in particular should be thoughtful about how they obtain it, when they need it, and what actions by a data subject actually qualify as consent. The difference between clear and freely given affirmative action versus silence and inappropriately influenced choice based on something like a tracking wall. Second, be careful about limiting genuine choice based on things like, requiring consent to perform a contract where the processing activity isn't necessary in order to perform that contract. Maintain an awareness of regulatory developments, specifically around these certification standards and other guidelines that are put out by the EDPB. And then finally, know that you can learn from other people's mistakes. It's a lot less painful, a lot less expensive. There will continue to be lessons from pre-GDPR enforcement activities. And then there will be the lessons we learn from the penalties imposed against organizations for violating GDPR. That's it for today's session. Jenna, do we have time for questions?
Yeah, we have a couple minutes, and this is a really great question, so I wanted to make sure we covered it. We were talking about data protection impact analysis. How do specific country DPIA requirements impact U.S. companies? Which DPIAs are leading, and which ones, do we need to honor?
So it depends on the processing activity of the U.S. or internationally based organization. If they're processing the personal data of data subjects in Austria, for example, then they would be wise to consider that whitelist. If they're processing the personal data of German data subjects, then they would be wise to consider the blacklist if that blacklist is implemented, or the blacklist in Belgium. So it's the importance is to think through whose data, what member state do they reside in.
Awesome. Along that lines, is there any guidance or idea of how large-scale processing is defined by GDPR?
No, not exactly. There isn't a number. I've seen numbers thrown out by people in the industry. I saw one suggestion that anything above 5%. So if a certain processing activity involved more than 5% or more of your overall processing activities, then that might be large scale. However, the guidelines published by the Article 29 Working Party and EDPB do, in the data portability section, give some examples about what constitutes large scale. I think also the data protection officer guidelines also include some discussion of large scale. So I think they talked about, for example, a hospital with its patients would be large scale, whereas a individual doctor with a single practitioner with its patients would not be large scale.
Another question is coming about DPIAs and the availability of whitelist and blacklist. Are those available to everyone online somewhere or easily accessible?
Some are, some aren't. I know that some of the things proposed in Belgium, at least in my research, haven't been published or in English, or at least where I was looking. So, but there's a lot of content written by people about those DPIA, whitelist, and blacklist. That's more readily available. So I would look to those.
Okay. And Mark, are you familiar with mask data and how GDPR would come into play with mask data?
So GDPR applies to data that's been de-identified, but doesn't apply to data that's been anonymized. I think if that's the gist of the question, that it's important to know that there is a difference between de-identifying information, which is basically when you split elements of personal data so that on its own, each, if you had two different pieces of you took one personal data data subject and split their personal data. So if you just had each piece, you couldn't identify them, but if you put them together, you could. That personal data is still covered by GDPR. But data that's been anonymized, which has been completely rendered with the inability to identify a data subject, that data is not covered by GDPR. So, for example, in researching considerations about video analysis, if an organization masks or pixels out the face of individuals in the video, that might be considered anonymized data at that point.
Awesome. That's all the questions that we have for today. Our next GDPR webinar is August 8th, so be on the lookout for an email from me for registration. You can also find the last 3 GDPR webinars on our website if you go to the webinars section. And specific to today, since we were talking about privacy policies, we will have a privacy policy checklist coming soon, so be on the lookout for that among our other GDPR resources. Thank you so much, Mark. That was really insightful. I took a lot of notes myself. And everyone have a great rest of your day.